Does eminent domain promote economic development, or does it rob people of their homes and property? Find out next on Outlook Monmouth. Welcome to Outlook Monmouth. I'm Armen McOmber, your host. Over the past 5 years, the issue of waterfront redevelopment in the city of Long Branch has pitted the city and developers against existing homeowners. Using the power of eminent domain, Long Branch has sought to transform a modest waterfront community into an affluent economic center. This project has stimulated tax revenue, economic development, and tourism for the city. Opponents of eminent domain argue the progress has come at a cost: the displacement of homeowners and the dismantling of communities. Recently, the city of Long Branch, developers, and homeowners struck an agreement to halt pending eminent domain actions. What lessons can be learned from the conflict, and what is the future for eminent domain in New Jersey? We are fortunate to have with us today representatives from both sides of the struggle. James Aaron serves as city attorney for the city of Long Branch. Mr. Aaron is the managing partner of the law firm of Ansell, Zarrow, Grimm, and Aaron in Ocean, New Jersey. Christopher Healy is an associate with the law firm of Bathgate, Wegner, and Wolf in Lakewood, New Jersey. Together with Peter Wegner and Pamela Mattis Snyder, Mr. Healy represents many of the homeowners who have been affected by waterfront redevelopment in the city of Long Branch. Gentlemen, welcome to Outlook Monmouth. It's a pleasure to have you here.
Thank you. It's a pleasure to be here.
Mr. Aaron, maybe I'll start with you. For people that don't know what eminent domain is, maybe you could just provide a general explanation of what it is and the process by which a city goes through to use it.
Armen, if I gave you the long answer, it would be out of time, so I'll try and keep it very short.
Okay.
The concept of eminent domain is the paying to the property owner fair market value for the acquisition of that person's property for a public purpose. And therein lies the rub in this case: what is a public purpose? The process, as you've asked me about for the city of Long Branch, required that the city, as a governmental agency, first asked the planning board to do a study of an area that it deemed to be potentially able to be declared an area in need of redevelopment. That area included general areas, beachfront north, beachfront south. When the planning board, the matter is then referred to the planning board conducts its studies. Not only does it studies, but it brings in consultants who discuss the requirements of the statute with the planning board, and the planning board makes findings, sends them back to and recommendations, sends them back to the governing body, and the governing body accepts or rejects them, and then an area is declared in need of redevelopment through that process.
I think when most people think of eminent domain, they think of a public purpose. They think of a city taking some land, making a park out of it for a road. In this case, and I think the area we're talking about for most people is the area around Pier Village, on the ocean in Long Branch and those areas. Can a public purpose be a redevelopment for private development, for a mall, or for this kind of a use?
The redevelopment statute itself, in its preamble, states that if an area qualifies for as an area in need of redevelopment, it is a public purpose. So the statute answers the question, but it doesn't necessarily tell you whether or not the municipality has met that burden of showing that the properties are in an area that is in need of redevelopment.
Well, let me ask that question then, and Mr. Healy, maybe you can chime in here, but what's the standard? How do we define what an area for redevelopment is, what blight is?
Well, the definition of what blight is up for debate right now. The city had made a determination in this case as to what blight was based on the criteria in the statute. The courts ultimately determined that they didn't do enough, and that there needed to be a more detailed hearing to determine whether or not this area was in fact blighted.
But in general, though, I mean, when we define an area of redevelopment or a blight, I mean, I think we know it when we see it. We certainly know the area around Pier Village was an area that needed redevelopment. There were derelict structures. It was in disrepair. But beyond that, unless something is completely vacant or something is run down. I mean, how do we define blight? Because it sort of gets to the core of the matter, and we'll get into how the courts dealt with it at some point. But is there a definition of blight? Is there a definition of what defines an area redevelopment, or is it something that's subjective on a case-by-case basis?
Well, I can answer the question
Sure.
from the city's perspective, and I think from any municipality's perspective. The statute sets forth 5 different categories that must be analyzed in order to find an area in need of redevelopment. The former blight statute was exactly the same. The language never changed. Those criteria go from the dilapidation of buildings being unsanitary, unsafe, the configuration of buildings being such that people cannot traverse the area appropriately. It goes to the conditions that exist in the area. In Long Branch, you had a burned-out pier. You had a rat-infested water slide. You had areas that were right around the area in question that had a landfill on it. You had houses that were crack houses.
There was a landfill?
There was a landfill directly south of, and properties directly south of the Matosa area, which is part of this discussion.
Was it a legal landfill?
It was a pre-existing landfill long before ordinance were ever in existence. That is now a townhouse, and part of the original contractors and developers project. That was phase 1 of the project. You have other indicia of physical attributes of a municipality where you see vacancies of properties get larger and larger and larger. Instead of developing, they become worse, and abandoned properties, abandoned businesses. These are all the things that a planning board looks at, and that's what was done for an entire area in 1995 and 1996 in the city of Long Branch.
And the origins of eminent domain, or of this redevelopment process around the Pier Village area. I mean, the city undertook this in 1996. This is when that started?
The process started in 1994 when the city was approached by a group, non-political, Long Branch Tomorrow. It was made up of citizens and organizations, the Monmouth Medical Center, Brookdale College, Monmouth University had representation, the utilities of the JCP&L, New Jersey Natural Gas, the Chamber of Commerce. These people got together in a citizens group, put together a fund to hire consultants and urged the city to go forward to redevelop the city. This is not the first time that had happened. That effort started in the 80s, and the hotel on the oceanfront was built as a result of a prior redevelopment project. That group wanted an expanded study, and that was eventually recommended to the planning board.
Okay, and the planning board adopted that study?
No, it adopted it in part. It knocked out part of the study area, found it not within the requirements of the statute. And that was an area directly south of the presently existing redevelopment area.
Okay. And Mr. Healy, you represent homeowners.
Right.
And where are these homeowners in relation to, and again, I think most people know where Pier Village is in Long Branch. They know where Beachfront North is, where all the townhomes and the development. Where are your clients, where are they located?
The clients that we represent are in the Matosa area of Long Branch, which is...
What does that stand for?
It stands for Marine Terrace, Ocean Terrace, Seaview Avenue. Those are the 3 streets that contain the properties of the clients that we represent. It's just north of the condominiums that are there now and just south of where 7 Presidents and the Lighthouse ice cream.
Well, I know where that is. Italian Ice, actually,
Yes.
which is very good. How many homeowners are we talking about?
I think it was somewhere in the neighborhood of 36 homeowners that we were representing in this.
And what, when you were first contacted, or when your law firm was first contacted by homeowners, I mean, what was their I mean, it sounds like, to someone listening to Mr. Aaron, it sounds like the city went through, a very comprehensive process, and came to a reasoned conclusion within the statute that this was an area in need of redevelopment, and they did their due diligence and did the proper studies. What were your clients, what was their dissatisfaction with the process?
Our clients came to us in 2005, 11 years after the process had begun, and they came to us because all of the sudden, the original redevelopment plan that was adopted had their property listed as residential infill, which is a term that permits existing homes to remain in the redevelopment area. Thereafter, they looked at 3D scale models of the redevelopment project that showed their homes in it. And then over the course of time, the city of Long Branch, without properly notifying our clients, changed the scheme. And all of the sudden, their assurances that they had been provided that their homes wouldn't be taken, the evidence that was shown by the city that their homes would be infill and shown as infill on 3D models, all of a sudden was no longer the case, and they were being condemned by the city. And so they came to us and said, the rules of the game have changed. Our properties were supposed to be saved, and now they're not. And so hence the beginning of our struggle with the city.
Did they were these homeowners, were they involved in the planning board process from the beginning?
They were noticed of the planning board process at the original redevelopment plan, and some of the folks attended those meetings. What they weren't given proper notice of is the various amendments to the redevelopment plan that slowly over time changed the designation of their properties from residential infill to being able to be condemned and taken.
They weren't given any notice, or they weren't given enough notice?
They weren't given a notice that a layperson could understand as a threat to their property rights.
Okay, and I'm sure Mr. Aaron will have something to say about that when we come back from the break. But one more question. Was there an attempt to negotiate with the city at that point, or did you go straight to court?
Well, there were attempts to negotiate in the context of the condemnation actions to make sure that the homeowners were getting the appropriate amount of money for their property, but as well as negotiations to allow the property owners to keep their homes, but those negotiations failed.
Okay. We're going to go to a short break. Please stay with us for more about eminent domain and waterfront redevelopment in the city of Long Branch here on Outlook Monmouth.
When you open a book, you can explore new lands, meet new friends, and discover new adventures. There are amazing possibilities when you open your mind to reading. You can log onto the Library of Congress website and let the journey begin.
Hello, my name is Max Weinberg, and I'm a musician, but most importantly, I'm a parent. To best understand the challenges that our children face every day, well, I'm going to ask you to go back in time and remember the challenges that you faced as a child. How did you know what the right choice was? Prevention First is a nonprofit agency in Monmouth County that offers educational programs dedicated to strengthening the foundation of our children's lives.
Do you know that stroke targets by color? Odds are, if you're African American, you're twice as likely to suffer a stroke as white Americans. Know where you stand. Because beating the odds isn't about winning, it's about living. Join the power to end stroke at strokeassociation.org.
Welcome back to Outlook Monmouth. I'm your host, Armen McOmber. If you're just joining us, we're talking about eminent domain and waterfront redevelopment in Long Branch. James Aaron is the city attorney for the city of Long Branch and the managing partner of the law firm of Ansell, Zarrow, Grimm & Aaron in Ocean, New Jersey. Christopher Healy is an associate with the law firm of Bathgate, Wegner & Wolf in Lakewood, New Jersey. Together with Peter Wegner and Pamela Mattis Snyder, Mr. Healy represents many of the homeowners who've been affected by waterfront redevelopment in Long Branch. So now we're back. The city's involved in litigation with a group of homeowners united against eminent domain and presumably the developers. Mr. Aaron, from the perspective of the city attorney of Long Branch, what were the issues that were litigated, and how did the court decide on the issues both before the Superior Court and the Appellate Division?
Well, basically, Armen, and thank you for the opportunity to respond. The city litigated the issue that was really before the court, and it was not really the issues that were brought up by the property owners originally. The structure of eminent domain changed when many years subsequent to the city's finding this area in need of redevelopment and the development actually moving forward. The case of Paulsboro, a Paulsboro case, was looked at by the Supreme Court, and it put stricter standards on municipalities in how they arrived at the conclusion that areas that they designated to be in need of redevelopment were so found. And what the court said in the Long Branch case was, Long Branch, we want you to go back and revisit what you did roughly 11 years before to see if, in fact, it really met the standards, because we're not convinced from the reports and the resolutions and the record below that Judge Lawson did that appropriately, and we want you to go back. We order you to go back and do that. And take another serious look at it.
In terms of how you noticed, or in terms of how the city designated, or the planning board designated, these areas in need of redevelopment?
Two things. First, with respect to how the city determined the area was in need of redevelopment. And secondly, the right for the property owners to even challenge that designation 13 years later or 11 years later was given to the property owners by the court in the DeRose versus Jersey City and Hoboken cases, where the court said if a property owner's property is going to be taken through the redevelopment process, not the eminent domain process, but the redevelopment process, at the very beginning, when notices go out that the area is going to be studied, you need to tell them, A, your property rights will be affected. B, your property as a result of this designation could in fact be taken by eminent domain. And C, that you should have the absolute right to come in and challenge the city's right to use your property as part of this section. That was a new judicial activist opinion of the court that didn't exist in the pre-existing statute and hadn't been part of judicial decision making process before that time. So although the city didn't object to that, this decision really gave the property owners additional standing to come back and sue on the merits.
And Mr. Healy, you know, I'm an attorney. To me, that sounds a little unfair. It sounds like the court is going back in time and changing the rules and changing the standards. And it sounds like, it's a little bit unfair to the city of Long Branch. What's your perspective on what the court decided?
Look, the redevelopment process is essentially the government coming in and saying to a private homeowner, I can do a better job of making your property, of managing your property than you can do. And if the government is going to do that, it's appropriate that the government take the necessary steps to make sure folks are aware of the fact that the government wants to do that. I think that what's probably more important to this case than the notice aspects is that the courts determined that the city of Long Branch didn't provide enough evidence that the properties in Metosa were in fact properties that needed to be redeveloped. And the reason that the court found that is because the fire marshal did drive-by inspections looking at cosmetic details and determined that because a wall, or not even a wall might be cracked, but a brick might be cracked or some other cosmetic detail was lacking in the property, it needed to be redeveloped and was properly defined as being blighted. And the court properly said that that's not enough. You need to go back and you need to figure out why these properties are in fact blighted. And I think that one of the reasons that the case ultimately settled was because the city of Long Branch couldn't do that.
Mr. Aaron, on its face, that doesn't sound right. The fire marshal just driving around and noting that some bricks are out of alignment or there's a pothole. I mean, is that what happened? Is that how the city determined that certain areas were blighted?
The answer is absolutely not. Keep in mind that this was not an area in need of redevelopment in itself. This was part of a much larger area that was all declared an area in need of redevelopment at the time. What was not in the reports were the growing number of vacancies, the deterioration of properties, the crack houses that existed, the overcrowded conditions that existed in the immediate area, the landfill that I mentioned, and the city was not afraid of a remand hearing.
None of that was in the Metosa area, though. None of those things.
But that was not, the Metosa area was not a separate area. That is my point. It was part of the entire area. One of the arguments that Metosa had was you don't need our area to do your redevelopment project. That was another area that was discussed, and the city would have had to deal with that on remand. But from the city's perspective, the city settled this case, not because it was afraid of the remand, but several things happened. One, the economy collapsed. Number two, the developer who had the contractual rights to develop the area said to the city, we're not developing anymore because we can't make any money. And C, there was an agreement that was reached that kept the area in need of redevelopment, allowed the property owners to keep their homes and actually get developer status, which is in the agreement. It allowed the developers to maximally develop those properties that they've already acquired in the area. And of the 36 parcels that were in the area, the developers controlled roughly 20. 16 were in litigation at the end, and some of those 16 people, in fact 3, had already opted out and asked their properties to be acquired. Additionally, the city would have been put in a difficult position, if not impossible position, because without a developer, the city under statute is obligated to buy the properties. And under their agreements, the developers would fund it. If there are no developers, then it would have to be funded by public money, which would have cost the city millions and millions of dollars based on the date of condemnation and the date of valuation, which would be at the height of the market and have no one to develop the property in accordance with the plan. So the settlement made sense.
The economy has something to do with this settlement.
More than a little bit.
More than a little bit. Let me ask this question, because I think for most people who followed this, they know end eminent domain abuse. They know some of the allegations have been floating out there. First, that the developers intentionally purchased certain properties in the Metosa area, boarded them up to depress value. And also, there's a feeling out there among some people that, the idea of conveying people's homes to private developers for profit doesn't sit well with them. I'm going to ask you both to respond to that. Number one, are the allegations true? And number two, is there just a general discomfort politically, emotionally with this process right now in Monmouth County?
Well, first of all, the area was declared in need of redevelopment in 1995. The plan for the development was done in 1996. There were no developers for 5 years. So the city didn't do this and declare the area in need of redevelopment knowing that 5 years later they would find someone to come in and develop. So that in itself is not factually true. It cannot be sustained. With respect to the value of the property, under state statute, when the city files a complaint that says we're going to take your property, that date sets the date of valuation. And here, coincidentally, had the property owners allowed their properties to be taken, they would have been valued as of December 2005, the very height of the market. And the developers and the city would have to pay that value, not the value that exists in 2010, so that the property owners would have gotten far, far more money now than conceivably even their properties are worth today, even though they own them.
But they didn't, that's not what they were after. They wanted to keep their homes. They didn't want to maximize the value of their homes and go somewhere else. They wanted to stay. They'd been there for 30, 40 years.
Well, let me ask you, Mr. Healy, how could this process be improved? I mean, how could the eminent domain process, the statutes, the way the courts look at it, how could this be improved so that people have a clear understanding of what their rights are, A, and B, municipalities have some indication as to what the law is before they proceed down this path? Because it seems very subjective and obtuse, at least to me.
I think that a couple of things can be done. I think that there could be a clearer, more objective understanding of what blight is, whether that be done by legislation or whether it ultimately be done by the courts. I think the courts are making steps to make the understanding of blight much more specific than the statute reads. And I think that the other thing that can be done is to make sure that there are adequate procedural protections for homeowners.
Mr. Aaron, you disagree with that?
No, we agree. After 28 minutes, we finally agreed. The whole bone of contention is how the statutes are written and whether or not whether the legislature wants to keep the process of redevelopment and the use of eminent domain alive in the state of New Jersey. From a general municipal standpoint, if you don't have redevelopment with the ancillary powers that it gives the government, given the state of economy today, given the COA obligations, given all of the DEP regulations, chances of redevelopment become slim and none unless you have these powers.
Thank you both very much. That's all the time we have for this episode. I'd like to thank our guests for an informative discussion. Join us next time for Outlook Monmouth. And again, thank you both.
Thank you.
Thank you.